SF check, $100 to $500. So that brings us to what we're here for today, is the sentencing. I have read Ms. Starlin's statement. Mr. Carnes, does she wish to address the court at all today?
No, Your Honor. Thank you for asking.
All right. Mr. Harrison, I'll turn to you then for allocution.
I think this case has had a unique enough history, at least in this court, to show a couple of things. One, Mrs. Duvall was in some degree of financial difficulty at that point in her life. And her daughter, who is cognitively challenged enough that she tends to believe things that people tell her. I'm talking about Kayla. And she came to Barbara with this story about this check from an account that she didn't open, from a person she didn't know. And if Barbara were thinking about how she might react nowadays, she might have said, Kayla, we've been down this road before. That's not really your money to access. But at the time, she didn't do that. Instead, she thought, maybe if I act quickly enough, I can use this money to pay off some debt that was kind of left over from the estate of my late husband. And I can maybe cover it up a little bit. Before anything gets sorted out, at least I won't be up against that deadline anymore. Maybe I can buy some time once this ruse is discovered. I don't have a lot to add to that story because I think the rest has all been covered pretty succinctly and pretty eloquently here, in that we know the next steps in the equation. We also know that at the time she took Kayla to the ATM, she made a deposit for $5,100. She only made a withdrawal for $200. And as far as we can tell, that money was spent between her and Kayla that evening, going out for dinner or something like that. And I guess more importantly, she didn't make any further effort to attach any more of that money. Having had second thoughts that evening, the bank acted quickly enough, so I'm not saying she would have been successful, but the concern for the court might be that she had a design or an effort after that point in time, and I don't see any evidence of that. I think it's difficult for someone like Barbara, who has had some difficulty in her situation financially. She has special needs children and is constantly, she believes, behind the gun financially. I think desperate times make people do desperate things, and I think that's what we're seeing here. I get the idea that Ms. Starlin certainly believes, and I know Clarinda Starlin. I used to work closely with her. I have no reason to believe that she's conflated or made up any portion of the story, so that's not what I'm saying. Seems to think this is more of this is the time Barbara got caught. I don't know that that's true. I don't know if that's something that the court even wants or needs to consider here. I see this as a one-time, a pretty narrowly defined situation. A check was procured that all the parties, probably even including Kayla, realized was not any good. And they made an end run around her guardian to test it out and see if they could get some money away along the way. Some people And I'm not ascribing this to Barbara particularly. Some people view this type of thing as, frankly, a victimless crime because the only one that's out the money is a bank. Well, I don't think she sees it that way, but I think it is one of those things that becomes easier to perhaps justify in the moment. That you're not stealing this from some poor old lady. If anybody you're stealing from, it's an faceless institution in Wisconsin or Minnesota. I often get the two of them confused. They're the same place to me. At the end of the day, and I've struggled with this a little bit, you can probably tell I'm off my usual rhythm in making an allocution or a speech, coming to a nice, concise conclusion for the court. I'm torn as to what I would even propose to have the court do here. I can say this, she has no prior record. She is a woman of a certain age that we will not say out loud. And she's managed to get through life thus far without amassing any sort of criminal record. So it doesn't appear to me that she is a serial con artist or anything like that. However, I think the events in this case should give everyone a bit of pause. Everyone besides Clarissa Starlin, who, thank God, was alert on her post at the time and perhaps averted a more serious situation. And perhaps a period of supervision and contemplation is in order here. Thank you, Your Honor.
Counsel, before we proceed further, there's an issue that I probably should have addressed before, but quite frankly, it escaped me until I heard Mr. Harrison talking. And that is Ms. Starlin was the appointed personal representative of my brother's estate some 10 years ago, maybe.
Okay.
I don't think that that raises an issue for me to be able to impose sentence because she would be, through her action as a guardian, would be considered the victim in this case. But I just wanted to raise that for everybody's consideration.
That I guess I would view it in a similar light that I worked directly with Ms. Starlin several years ago before I became a public defender, but none of that would have colored anything that I had to say about her or her involvement in the case. So I don't view that as a conflict.
And I will state that I will take her her written statement to the court the same as I would take any other statement to the court. So, so Mr. Harrison, you're not going to raise an objection to that?
I am
take
not.
it. All right, Mr. Carnes.
No, Your Honor, I have no objection as well. And I should state I worked with Ms. Starlin when I was a special assistant chief for adult services.
All right. Allocution.
Thank you, Your Honor. This is concerning. First off, there is a direct victim here, and it's not some fictional bank in Minnesota. It's Caleb Duvall. We are asking for $245 restitution to Ms. Duvall. Ms. Starlin did already pay that out of Caleb Duvall's funds. She's a direct victim. Also, I am concerned here, Ms. Starlin identified the handwriting on the check as being the handwriting of Ms. Duvall's. It's not like this check arrived in the mail already filled out. According to Kayla, Barbara wrote it all out and then told Kayla to sign the check. So there is, I think, more culpability than we got in the guilty plea, despite it still meets the factual basis, especially for the resolution. But those things give me pause. It seems as though the defendant has issues with the truth, which was also noted by Trooper Campbell, although she ultimately did confess to all of this. She made several inconsistent statements throughout the investigation. I am also at a loss, as far as what to do for sentencing. I think it's important that this charge go on the defendant's permanent record, just as a heads up to everyone. I should also state, and I know Ms. Starlin, wrote this in her, victim statement. It also does not seem that this is the first time anything has been done, as there is an ongoing issue in Manistee County regarding one of defendant's other daughters, who had a structural settlement that seemed to have been missing funds. Defendant is the suspect there. That's quite frankly a much more serious matter that I think is still under investigation. Defendant is elderly, has some health issues, so I'm not sure jail is the best sanction here, but I do think there does need to be a sanction. I would be what exactly that is in the court's discretion. Thank you.
Thank you. Mr. Harrison, Mr. Carnes brought up restitution in the amount of $245. Is there a stipulation to that?
Indeed.
All right. Ms. Duvall, you had the right to address the court prior to sentencing. Is there anything you'd like me to know?
Just that I'm very sorry that I made a mistake.
Anything else?
Yes.
Anything else you'd like me to know?
So,
All right, well, first of all, this was not a mistake. I mean, you knew that your daughter did not have the money in the account. You knew that she had a guardian, that she couldn't do her own banking. Contrary to what you expressed to the court last time we were here, Ms. Starlin put in her victim impact statement that you turned over 2 packages of checks to her. That's a big difference than one check arriving in the amount of $5,100. Already pre-made out. Now I understand that there's might be an investigation somewhere else. I'm not taking that into account. I'm taking into account what has been presented to the court and what I have in front of me as far as convictions. And I agree that you don't have any convictions on your record, but the fact remains, you knew what you were doing. Otherwise it wouldn't have happened. Mr. Harrison states that you're not a serial con artist, but I'll be honest, at least as presented in here, what I've read in Ms. Starlin's statements, the probable cause affidavit, and what I've heard from counsel and what I've read in the PSI, this isn't something that just happened on a whim. This is something that may not have taken a lot of thought, but it took some thought. And not only that, but you preyed on your daughter who has, I don't know exactly what all she suffers from, but it's enough that she has to have a guardian. She works at after 26. She makes limited amount of money. I'll be honest, I've toyed with this case every time it comes up in front of me as to what to do. Ms. Starlin doesn't think that jail is appropriate. Mr. Carnes doesn't think jail is appropriate. But I guess what is appropriate? Probation? You knew what you did was wrong. No number of classes I give you can tell you and teach you that what you did was wrong. You know this was wrong. So I question whether probation is appropriate. I question whether community service is appropriate. I mean, the community will get something back, but that doesn't necessarily help your daughter. It doesn't help Ms. Starlin. It doesn't help the bank. And so I'm left with what do I do? I mean, and as I said, you don't have a criminal history. And I don't know what health conditions you have. I know it was alluded to in Ms. Starlin's statement, and Mr. Harrison and Mr. Carnes both brought it up. And I also realize that, you're not, nobody wants to say your age, but you're not 70 yet. But you're not 20 either. And so I, as the court, have to determine what can I do for deterrence? What can I, not only for you, but for everybody else who find themselves in this position? And what can I do to, as a form of punishment? Because again, no matter what I do, it doesn't remove the fact that you preyed on your vulnerable daughter in this situation to what appears to attempt to benefit you. Not even to benefit her, but to benefit you. And that is just completely, I will tell you, Ms. Duvall, I see a lot sitting in this chair. I saw a lot sitting in the prosecutor's chair, and I saw a lot sitting in the public defender's chair. But this type of behavior, it sickens me. There is no excuse for what you've done. Sentence today will be 15 days jail with 0 days credit, 24 months of probation. During that period of time, you're not to violate any law. Report is ordered not leave the state of Michigan without the consent of your probation officer. Keep your contact and employment information current. You are eligible for early release on this, so it's possible that at the 12-month mark, you might be able to be released from probation. Ms. Starlin, I'm going to ask you, what are your thoughts on a no contact order?
Well, she lives with, they live with her.
Okay.
My concern was I would like to have her be ordered to have do a psychological evaluation so I can determine what I need to do with the four adults.
Are you guardian of all four?
Yes. They all have learning disabilities.
And so you're asking for a psychological evaluation on Ms. Duvall?
Yes.
All right.
I don't know, one of the boys is going to be the next victim, or if this is going to be the end of it.
I am going to do this. I'll order any programming that the probation officer feels is though appropriate. I'm also going to order that a psychological evaluation be done.
Thank you.
Community service work, I feel, even though that the victim might not be compensated by community service work, I will order it. I'm going to order that there be 30 hours of community service done. Life coping skills, and any other counseling that the probation officer feels is appropriate. There is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee. $150 court costs, $150 attorney fee. Despite my temptation, I will keep the fine to $150. 12 months of community service is $360. If you stay longer than 12 months, you'll be required to pay the monthly fee on that. Restitution in the amount of $245 to Ms. Duvall. Anything else in a judgment of sentence, Mr. Carnes?
No, Your Honor, thank you.
Mr. Harrison? Ms. Duvall, because I have sentenced you to a period of incarceration, you do have the right to appeal that decision. If you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. Also, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that. Because of your financial situation and as long as you're compliant with probation, I will waive that 20% penalty unless it's not paid by the end of probation. Right, ma'am, you'll have to go with the bailiff.